I'm Cynthia Rowland, and this is episode 54 of EO Radio Show. Today, we are again lucky to have my partner Quinn Arntsen with us to talk about leasing issues for nonprofit tenants. In the previous episode, we talked about term sheets and the key issues there. Today, we'll take a deeper dive into the lease agreement itself, including those boilerplate provisions and why they matter to the nonprofit tenant. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. I'm happy to have Quinn Arntsen here today to talk with me about leasing issues for nonprofit tenants. Quinn is a partner at Farella, and he divides his practice between traditional real estate work and advising clients in the wine industry on transactional real estate matters. Quinn has represented clients in a wide range of projects, acquisitions and dispositions for real estate developers and investors, representing borrowers and lenders on real estate secured financings and loan workouts, landlord and tenant side leasing of office, life science, research and development, industrial and agricultural real estate, and negotiating and structuring joint ventures and other real estate investment entities. He also assists private clients on many real property issues. As you will no doubt notice in my conversation with Quinn, he combines a calm, low-key demeanor with exceptional analytical abilities and an outcome-focused approach. His goal, as always, is to get things done. With all his clients, Quinn knows their industries, understands their needs and overarching goals, and can help them focus on what is really important. Many of my nonprofit clients have had the pleasure of working through real estate transactions with Quinn, including standard office lease projects and tricky property management agreements. He's an absolute pleasure to work with. Welcome back to the show, Quinn. Thanks for taking the time to have a conversation again today.
Yeah, thanks for having me back.
In a previous episode, you and I talked about term sheets and letters of intent and covered things like the overview of the process, getting from the term sheet to the actual lease agreement, and some of the key topics that are addressed in a term sheet, like the description of the premises, the term and termination, term extensions, base rent, operating costs, taxes, tenant improvements, and security deposits. As we launch into a lot of this nitty-gritty, you want to talk a little bit about why the things are in the term sheet, and then some of the stuff that, like what we'll go in today, isn't usually in the term sheet, but is very important. You know, how do you break these things down between what you first talk to the client about in the term sheet and then how the whole thing develops into a final lease agreement?
Yeah, so the term sheet items are, honestly, the more important provisions. They're the things that often impact dollars and cents, that impact the actual operation, the tenant's actual operation in the space. So they just matter more. The tenants also usually care about them more. As a tenant, you don't really care about insurance or condemnation or indemnity and things like that as much. They end up mattering, but they aren't the things you want to make sure are right from the outset. So that was kind of how we split it up. It's also, the term sheet can only be so long. They're usually maybe 2, 3, 4 pages. Leases themselves can often run over 50 pages. So there's just a lot of other concepts, a lot of other issues that need to be addressed in the lease. They aren't as interesting. They aren't as likely to come up, but they do still matter. And it is good for tenants to understand them and also make sure they aren't being taken advantage of in leases.
I know you'll get into this in all this nitty gritty detail, but one thing that I often see with the nonprofits is that they get through the term sheet, then the landlord hands them a really boilerplate lease agreement and says, here, sign this. A lot of nonprofits do have real estate counsel, but many don't. I guess as we go through our conversation today, maybe talk about how the client tenant can think about that boilerplate. They may not want to go hire a lawyer to rewrite the whole thing, but I know from past experience with you that there are addendums that can be easily added and some things that as we address these points, you may not want to redraft the whole thing, but just address it separately. I don't know where that fits into your overall conversation, but I just wanted to mention that at the outset for the listener that's a tenant that's been handed this boilerplate and they're like, well, I can't take advantage of any of this stuff Quinn's talking about because the landlord just handed me a template or handed me a form and said, sign this. We got the rent right. We got the term right.
Yeah, I mean, so that's actually a very interesting point and probably worth chatting about a little bit before we get into the more nitty-gritty issues. When you're given the lease, the first priority is to make sure the business terms match up with the term sheet. As an oversimplification, if you have the form lease and the business terms match up with the term sheet, you were fairly happy with the term sheet, that lease is going to work for you. It's going to work well enough as long as things don't go wrong. What we're discussing today are the provisions that come into play when things start to go wrong. So if you're an optimist, maybe you say, hey, I'm willing to see how this goes. Business terms are right, rent's right, terms right. Great. I'll move forward with that. There are then a couple different approaches you can take to marking up or negotiating the lease itself. As you said, you can sometimes just add an addendum, just add a 2 or 3 page addendum that tries to insert tenant favorable terms. You can have language at the front that says these terms override conflicting terms in the lease to the extent there is a conflict. And you can really focus on some of the key points by doing an addendum like that. That is sometimes a good approach if the landlord is using one of the industry forms or broker forms. So in real estate, there are 2 main groups of forms. There's a California Association of Realtor, which are the CAR forms. And then there are the AIR forms. They're just base documents that are fairly middle of the road, like not egregiously tenant favorable, not egregiously landlord favorable. So if you get one of those, you could just add on an addendum and hope to streamline it that way. A lot of landlords, especially big landlords, do generally have form leases. They'll give it to you. They might present it as take it or leave it, but they're always negotiable. And even if you aren't doing a full markup, you could still have someone read through and say, hey, give me the 10 most important changes that we could make to this. And then you can go back with a simpler markup, and that can be a quicker process. Or if you're leasing a whole building for 15 years, it's worth putting in the time to negotiate the whole document. I mean, even less than that. If it's a significant financial outlay for you or significant potential liability, it's worth putting in the time to get it right.
Totally agree. And maybe we'll put those 2 base forms in the show notes. If those can you link to those on the internet, or are those generally available?
No, so they're proprietary forms that you can only use with proprietary software. Brokers have access, attorneys have access, but yeah, they're not
generally available.
Yeah, and they're all in locked PDFs that you can only edit using special software that you have to. It's a whole process.
Yeah, it's complicated. So with that kind of background, let's get into some of this nitty gritty. Just walk us through how you think about negotiating a lease once we've gotten past the term sheet stage and you are looking at the form of lease that the landlord has provided.
Yeah, definitely. So yeah, we're going to run through a number of points. These are less sexy topics than what we talked about last time, but they're still in there and they still matter. And the order isn't really order of priority. Believe it or not, it's the order they often appear in the lease themselves. So the first item to chat about is use. And so for the lease is going to say what uses are permitted in the space. One way to say that is that the tenant can use the space for any legally permitted use. That's broad. As a tenant, that's great. You can do whatever you want. More often, the use is going to be specific. So it's going to be office and ancillary things, or it's going to be an art gallery and studio and things related to that, or it's going to be a restaurant and back office, things like that. Like it usually will be fairly specific. As a first point, you want to make sure the use matches what you're doing. There are a couple nonprofit specific concerns here. So one is if the lease requires that the tenant use the space for nonprofit purposes, that is going to severely limit your ability to assign or sublease the space, which even if you go into the lease not thinking you might need to, things change. You might get 3 years into a 7-year lease and decide, hey, this space just doesn't fit our needs anymore. We want to get rid of it. If the lease has to be assigned to a nonprofit, that's going to be much harder than if you could assign to anyone. So something to keep in mind there. Another concern here is that if a nonprofit is conducting mission-oriented activities, so if you've, say, got a place that provides care for children, you are going to want to be very clear that that use is allowed. And you're also going to want to check the zoning code for where you are to make sure that use is allowed. Because there are a lot of things, like offices permitted everywhere, but daycare facilities aren't permitted everywhere. Places that serve food aren't permitted everywhere. Places that take care of animals aren't permitted everywhere. In addition to just making sure the lease describes the use correctly, you should do a little bit of investigation into land use code to make sure you can actually do what you want to do there.
All right, so that's really helpful. So we've thought about our use, our compliance with laws is a subset of that. Any hot topics that come up there?
Yeah, so compliance with laws, this is something that is always addressed in leases, and it might on its face seem like, oh, compliance with laws. Well, that's not an issue. We're going to comply with laws. We can move right past it. But it does have some further reaching implications. So you can think of compliance with laws in two different ways. So one, does the actual space, does the building, do the premises comply with laws? So that could be things like, are the bathrooms ADA compliant? Did the building undergo a seismic retrofit? Things like that. The other question is the operational compliance with laws. So is what's actually happening there complying with laws? This is similar to what we discussed earlier about if you're doing a childcare facility, you want to make sure that childcare is permitted there. So usually the operational compliance is on the tenant. That's the tenant's responsibility. But compliance for the actual structure, for compliance of the premises, compliance of the actual structure with applicable laws is heavily negotiated. And part of the reason there is a lot of compliance can be really expensive. So back when all the buildings had to undergo seismic retrofits, those were huge improvement projects for landlords, and they wanted to pass through the cost. If you're the tenant, you're like, hey, landlord, you've owned this building for however long. I'm only in here for 5 years. I don't want to pay all the cost of bringing it into compliance with the seismic requirements. So it is good to specify that. And as the tenant, you really don't want to be responsible for pre-existing noncompliance, or if the work to bring the space into compliance is capital improvements or capital in nature, you also don't want to be responsible for that. And if you are, you should try to limit it so you're just responsible for, say, a prorated amortized portion of that cost applicable to the term of your lease. You don't want to be in a spot where you've got 3 years left on a lease. Landlord does a ton of work and they try to pass all of it through to you because it occurred during your lease.
This issue in particular, it's really going to be informed by how long the term of the lease is, what your expectation for staying in the space. Because of the shorter your term, maybe the less important it is, because if it gets to be onerous, you just walk away and look for different space. I see the next thing on the outline, hazardous materials. If it's an office use, I'm like, oh, this doesn't matter to me. That can't be an issue. How does that come up in the typical lease that you see with a nonprofit?
Yeah, so that actually can. So something where this can come into play is for like an office lease, if there's, say, asbestos, like if there's existing hazardous materials in the building, there's a chance that during the term of the lease, the landlord needs to fix those. Landlord needs to remediate them for some reason. And if that happens as a tenant, you don't want to be responsible for that. Or say there's lead paint. You don't want to be responsible for the landlord's cost of going through and removing all that, repainting it. Kind of like that was an issue there before. Landlord, that should be on your dime. The other way hazardous materials comes into play is less so with office space. I mean, office space, technically like toners, a hazardous material. So there are a bunch of things just used for office, used in a typical office that are technically hazardous materials. So you want to make sure you can bring those in, but also just use them in compliance with laws. That operationally isn't as big an issue. But if you are in an industrial space, if there's manufacturing, stuff like that, if you've got a say, a more agricultural property and you're bringing vehicles onto the space, or you're storing oil or pesticides or things like that, it can come into play. So you do, as the tenant, you usually will be responsible for anything you brought onto the premises. You can't really get around that. So it's good to keep in mind, it's good to think about what you're going to bring on, make sure you can bring it on, and then make it clear that you aren't responsible for anything that predated your use. I guess those are the main concerns around hazardous materials.
Let's talk a little bit about alterations and maintenance and repair. I know those are two kind of separate things, but what are the key things to think about for those topics as we look at our form lease?
Yeah, so for alterations, the general idea and the way most of these landlord forms start is tenant, you can't make any alterations without landlord's approval. That makes some sense. It's the landlord's building. They're going to own it for forever. They don't want the tenant coming in, punching holes in the wall, being there, and then maybe they default and landlord's stuck with a damaged building, or maybe even they just continue the lease. And when the term ends, the tenant's done all this stuff that the landlord doesn't like or isn't going to be useful for another tenant. So the idea makes sense that you have to get the landlord's approval. But there are some ways to kind of caveat or give the tenant more discretion. One of the big ones is if, as the tenant, you know you're going to want to do things. Like say you're leasing an office. All right now this space is great, but we're pretty sure in 2 or 3 years or 1 year, we're going to want to combine these offices and make a bigger conference room. You can try to get something like that pre-approved because you will have the most leverage to negotiate this at the time you're negotiating the lease. Once you've signed the lease, you're in. The landlord doesn't really need to make you happy anymore. You're there. You have to keep paying rent. So the landlord doesn't really have incentive to agree to big changes, to anything. So that's one thing. If you know you're going to make alterations, try to get them pre-approved. The other is tenants should be able to have the ability to make minor alterations without consent. So sometimes that's as simple as like painting. Like technically painting's an alteration that usually would require consent. But you can often get cosmetic alterations, so things like painting pre-approved, or minor alterations like mounting a TV on the wall. Again, you're drilling into the wall, it's an alteration, but you can often get minor things like that pre-approved. Or you can say that landlord's approval is not required for minor cosmetic alterations. And then one other thing to keep in mind with landlord approving alterations is usually the leases start out saying that the landlord can require any alterations be removed, and it can give this notice at any time up until the lease ends. For a tenant, that's a pretty tough situation. Like you don't want to have put in a couple walls, made a kitchen bigger, done things like that. And then 5 days before the end of the term, when you're supposed to be out of there, the landlord comes and says, oh, I want you to restore this to how it was. I want you to undo that kitchen expansion, rebuild these walls, do those things. So it's good to have provisions in the lease saying that the landlord has to specify at the time it approves the alterations whether the alterations need to be removed. Because then as a tenant, you can fully factor in that cost when deciding whether to make it, and you aren't stuck with an unexpected bill at the end of the term.
That's all really helpful information to keep in mind. One thing I want to mention here for nonprofits, and that is that if improvements are made, whether they're significant improvements or minor alterations, if the landlord is a related party, a disqualified person, and the tenant is making the improvements, we need to make sure that the tenant is not providing a private benefit to a related party for-profit disqualified person. So for that, I don't want to do a deep dive into that, but if for any listeners where the nonprofit is contemplating leasing from a related party, private owner, where there might be private benefit from the improvements paid for by the nonprofit, go back and listen to our episodes on insider transactions. Sometimes it's possible to do it depending on the circumstances, but it's definitely a trap for the unwary if the tenant is paying for improvements or alterations that end up inuring to the benefit of a private party. So that's just a note, and we'll link in the show notes to those earlier episodes on insider transactions that'll touch on that specific nonprofit legal issues to be aware of. Moving on to maintenance and repairs. If I, as the tenant, damage something, that makes sense that it might be tenant's obligation. But talk through what kinds of issues come up there. When is it the landlord's problem? When is it my problem as the tenant? What kind of self-help is allowed?
This one, my response is kind of, it depends, which isn't necessarily as helpful, but it really does vary a lot depending on the type of space leased, the sophistication of the tenant, the sophistication of the landlord. Ordinary maintenance in something like an office building, the landlord's going to be doing all of it. Like the landlord's going to want to do all repairs. They're going to want to maintain the common space. They'll do all big things. On the opposite end, if a tenant's leasing a whole building for an extended period of time, usually the tenant's going to want to be responsible for all that. In those cases, the tenant has more obligation to maintain, has more obligation to repair. Hopefully that's factored into rent. Flip side, in the office building, you're likely paying more rent because the landlord's doing all this. The more important thing when negotiating the lease itself is to understand how maintenance and repair obligations are allocated and make sure as the tenant you're comfortable with what you're required to do and what the landlord is required to do. Similar to that, the leases often specify a standard. If you're in an office building, you go into a first-class office building, you want to make sure the landlord's going to continue to maintain it as a first-class office building and that it's not going to fall into disrepair or something like that. One interesting thing, and you mentioned this actually, is the tenant's right to repair and deduct. So oftentimes the landlord's responsible for maintenance and repair. And what if the landlord doesn't do it? The tenant's stuck in a spot like, hey, my pipe's broken and landlord, you haven't been out to fix it in 2 weeks. This is a huge pain. As a tenant, you want the right to be able to fix it. And then, okay, you've incurred cost to fix it. That should have been paid by the landlord. Well, you should be able to deduct that from rent. Even though that seems like an intuitive, fair outcome, landlords often push back on it quite a bit. I'm a little curious to see right now as the market becomes more and more tenant-oriented, if this provision comes into more leases, because it does just make some intuitive sense. But yeah, it's worth trying if you can get it, because it does give you more protection, especially if you have concerns that your landlord might be a bum or your landlord might be absentee and not perform. You'd like to have that, right?
Yeah, and it seems like as I was listening to you talk about it, I was thinking, well, this is definitely an issue if it's an older building, but maybe it's an issue for a new building as well, particularly for an older building.
Yeah, that's true. That's true. And that is something as you're negotiating the lease in the first place or picking out a property, it is good to chat with the broker, try to get the broker to gather information on the condition of the property. Sometimes you can even get information from the landlord or the broker on past maintenance costs. And if you see that, hey, this building requires a lot more money than we think it should to maintain, might let you know there are issues and maybe you fight harder for this repair and deduct right.
So, Quinn, let's talk a little bit about the provisions in the lease about utilities and other building services. What should we look for there? I've been mostly talking about office leases, but there may be other unique things you want to mention.
Yeah. So part of this will be addressed in the term sheet. Like the term sheet will specify who's paying for utilities. That's part of the rent structure usually. Often this will be addressed in the term sheet. But in the lease itself, you'll get into things like what are the hours utilities are provided. So if you're in an office building, HVAC, so heat, air conditioning, often only provided during certain hours. And sometimes there can be pretty excessive charges if you want to use it outside those hours. So it's good to review that and make sure that's consistent with your use. Similarly, things like, is the landlord providing janitorial? Is the landlord doing window washing? Who's responsible for light bulbs? Landlords will often be responsible for those things, so you want to understand that. In some situations, you can have tenants that have very atypical utility uses. So maybe they use a whole lot of electricity or a whole lot of water. in those situations, it can often be better for the parties to set up a submeter so that the tenant's use is specifically measured and the tenant's paying for its specific use. It sort of cuts down on the risk for both parties of either landlord stuck with a much higher bill than it expected, or the tenant is paying more than it's actually using. And then something else related to utilities is what happens when they go out. So say your water main into the building gets cut and the building doesn't have access to water for a week or two. What happens during that time? Because you might not be able to use the space at all. And if you can't use the space, ideally you aren't paying rent. So it's good to specify when an interruption in services gives the tenant the right to not pay rent. And in some situations, when it could give the tenant the right to terminate. As a tenant, you also have protection. You can get business interruption insurance, which will cover you for some of that. But it is nice if you also have protection in the lease.
Our next 2 points that I wanted to cover, but in the interest of time, I think we'll just touch on them very briefly. And one of them is segued just from what you just said, and that is about insurance. We have a couple of separate episodes on working with insurance brokers. Obviously, insurance provisions are super important in terms of what the tenant has to carry and what the landlord has to carry. And insurance is closely tied to that other risk management issue, which is indemnification provisions. So, without doing a deep dive on risk management, indemnification, insurance, any highlighted topics you want to mention there, Quinn?
Yeah. So on insurance, highly recommend having your broker review the insurance provisions as early as possible. It's going to take the brokers a while to review them. If the insurance provisions require that you get more or new insurance, the broker's going to have to go out and get quotes. That this can be a lead time item that delays leases getting signed. So have your broker review as early as possible. They'll tell you what's reasonable. They'll tell you what you can carry, what you don't carry, and how much it's going to cost to get more insurance. So try to get ahead of that one. On exculpation and indemnification, these are very important topics from a risk allocation standpoint, but they are very technical, very legal. The idea is essentially if someone sues or if someone gets damaged, who's responsible for the cost of that? So say a visitor is in the space and slips and falls in the lobby. And then that visitor sues the tenant and that visitor sues the building owner. Who's responsible for the cost of that? Who's responsible for the defense? So there are sort of intuitive ways to think about kind of what's fair and try to match it up based on what's fair. Parties will also sometimes try to match it up based on insurance, like who's carrying the insurance. So make it so the party carrying insurance is responsible for the indemnification. But yeah, they're complicated and messy, and that's all I'll say on that.
Our next 2 topics are also in the risk management arena: damage and destruction and condemnation of the entire property. Again, things that rarely come up, but they do. It's not necessarily something to completely gloss over. Any high-level concepts there to mention at this point?
Damage and destruction, what we're talking about here are something like a fire or an earthquake or a pipe breaks and your building or your office gets flooded. Again, these rarely come up, but they do sometimes. And when they come up, the lease governs. And I've had clients be put in tough situations where they can't use the space, it's damaged, and they're fighting with the landlord for an extended period of time over how you address that. And so, yeah, if you can get ahead of it in the lease, that is worth doing. I think the key things for damage and destruction are, as a tenant, you don't want to be responsible for the cost of repairs or replacements of things that weren't yours or weren't paid for by you. So you don't want to be responsible for tenants' cost or landlord's cost of rebuilding the building. You usually don't want to be responsible for the cost of fixing or replacing alterations that landlord made or paid for just for you. So those things, try to keep them on the landlord. You also don't want to have to pay rent for the time you aren't in the space. Again, you aren't using the space. It can get a little bit fuzzy with whether it's your fault or not, but assuming it's not your fault, assuming there's an earthquake, you aren't in the space, you shouldn't be paying rent. Now, again, you can sometimes get business interruption insurance that covers for that. But as a better starting point, you should just have the baseline of you aren't paying for that. And then the third thing to keep in mind is, at what point is it too long for you to be out of the space but still stuck with the lease? So if there's an earthquake and it's going to take 2 years to rebuild the building, you don't want to sit around waiting for 2 years to come back in, even if you aren't paying rent for that time, because you're going to need alternate space during those 2 years. You're better off just ending this lease, go finding your new space, and working from there. And that's going to depend a little bit on what you're doing in the space, how specialized it is, how long your lease is. I've seen these provisions go from anywhere from 120 days to maybe 18 months for when a party has the right to terminate. And then condemnation, this comes up even less often than damage and destruction. I've actually never seen it come up, but it's in all the leases. And here you're talking about something like eminent domain, where a city or governmental agency comes and takes a portion of the property or all the property. What happens to the lease? And the issues here are essentially the same as a casualty condemnation. You want to make sure you aren't responsible for repairs that are for things that are really like for the building, things the landlord owns. You want to make sure you're not paying rent. You want to make sure you have the right to get out if the taking is too material.
So that was a nice, dive into things that you really don't want to think about as a tenant going into a property. And on a not quite as anxiety promoting topic, but assignment and subletting. Some interesting issues come up here, particularly for nonprofits. There's some language in there in these assignment and change of ownership issues for the tenant that are worth talking about. Walk us through the importance of the assignment and subletting provisions in the typical lease and how the tenant can think about whether this is something they need to actually have modified or add to an addendum.
Assignment and assumption, or assignment and sublease provisions, are probably the most interesting or relevant thing we're talking about today, believe it or not. They can come up. They often do come up, and it can be unexpected. So it's not uncommon for a tenant to be in a space and you've got 7-year lease, 3 years in, you decide this space isn't right for you. You've either got too much or you don't have enough, and you either want to get out of this space and assign it to someone else. Maybe you want to sublease part of your space, keep operating there. These provisions can really impact your ability to do that. So at the outset of the lease, you should try to think about what your midterm plans are. Are you likely to want to sublet? Are you likely to want to assign? Occasionally, we'll have nonprofit clients that want to share space with an affiliate or want to act as an incubator. If you know up front that you're going to do those things, you should really get them pre-approved, because otherwise they are assignments or subleases that would require consent, and the landlord has broad authority over assignments and subleases, and they can impose conditions, they can take money, sometimes they can try to get the space back. It can get messy. But yeah, so they are worth focusing on.
Maybe less so in the current market, where a landlord's not going to try to boot us out because we've sublet and take the space back and release it at a higher rent. But on the other hand, sometimes there's profit sharing provisions in there, or you have to give a share to the landlord. Those things could be material even in this market.
Absolutely. So most leases say if there's an assignment or sublease, the tenant has to share. You can think of it as kind of excess rent. So if tenant's paying $100 per the space and tenant's able to sublease it for $120, then you've got a $20 difference there. Who gets that? Sometimes landlords try to say they want it all. Frankly, I think that's a bad strategy because it completely disincentivizes the tenant from wanting to sublease. And if subleasing is money making, why not share the money? But so more common, it's the landlord and tenant have to split whatever the excess rent is. And then tenants can deduct their cost of subleasing, their legal fees, broker fees, etc. As part of the consent process generally, so the tenant wants to do it, the typical standard is the landlord can't unreasonably withhold consent. But that unreasonably has a pretty big asterisk on it, because the lease will often say, well, it is reasonable for the landlord to withhold consent, 2 assignments to someone else who's in the building, to anyone the landlord's talked to within the last 6 months, to anyone who's a government entity, to anyone, the list can go on and on. So it's good to think about that. You want to try to narrow it to have the assignment right be as broad as possible. But also, I mean, some of them probably aren't going to come into play. So I guess you don't need to fight too hard.
I guess that there's 2 main scenarios that I think of where that even comes up. One is when the tenant has extra space but wants to stay in the building, and this is just a convenience, best good practice, all that sort of stuff. And there's not really a problem with the space or the tenancy. And then the flip side, which is a transition to another topic on our outline today, and that is when the tenant is at risk of defaulting. We can't make ends meet unless we sublease some space and are able to get somebody else to pay the rent. So you want to talk a little bit about what default looks like and the provisions that come into play and how the tenant can focus on these provisions, because a lot of this stuff is very much hard to understand if you're not a leasing lawyer. These default provisions, I think, are really technical and don't necessarily mean what they seem to say, or they mean a lot more than what they say.
That's true. That's definitely true. And there can sometimes be a laundry list of things that constitute defaults. So the most common and the most easy to understand is failure to pay rent. So the tenant doesn't pay rent, that's a default. Other things are if the tenant abandons the property or abandons it and doesn't leave it secured. Like landlords don't want just vacant buildings. Those are liability risks. So that's why that default is often in leases. Other defaults can be if the tenant doesn't deliver an estoppel or SNDA as required. The reason for that is that could jeopardize the landlord's ability to get a loan or sell the property. So that actually has a big dollar impact on the landlord. So they'll keep it in there, often with a shorter notice and cure period. And as a tenant, you're like, why do you care about this? Why is this so big? Well, the reason for that is because it could jeopardize the landlord's ability to sell. Other defaults are transfer violations. So if you assign it or sublease when you shouldn't, or if you become insolvent, there are bankruptcy concerns around that. But leases will often say if tenant becomes insolvent or files for bankruptcy, that's a default. And then kind of the catch-all is any other breach of the lease. That catch-all is probably the most common one to come into play, other than maybe failure to pay rent. It's you violated something else. You made alterations that you shouldn't have made. You let dogs come into the space when you shouldn't have let dogs come in. You didn't repair this thing that you were supposed to repair. The big thing on non-monetary defaults is the cure period, the notice and cure period. So almost always there will be something saying you're in default if you don't fix the breach within 30 days after notice or something like that. So it's good to get as much time as you can. And also, if something can't be cured within, say, 30 days, to make sure you're allowed to fix it after 30 days, as long as you're working on it. Those are the main concerns around defaults and cure periods. Something else to keep in mind is that what leases say about defaults and tenants' remedies often don't actually match what California law says about these topics. So leases can sometimes say the landlord can do A, B, or C if the tenant defaults. But in reality, the landlord can't actually do those things. Like the landlord cannot kick out the tenant unless the landlord goes through an unlawful detainer proceeding. And that takes much longer than just a couple days or much longer than just right after tenant fails to pay rent. So if you're in a dispute with a landlord, if there's been a default and landlord's threatening things, it's a good idea to talk with a lawyer to really understand what the risks are, what the process is when the landlord could actually start doing all these horrible things they're threatening to do.
Yeah, that's really good advice. It's the may not be what it seems in the lease, and so get some help on that. A similar issue here, other things that are kind of boilerplate, but they may be a little dense for the tenant to understand, like the landlord's right to come onto the property, the things that come up when the tenant stays in the space after the term, landlord encumbrances. There's a number of other issues, and I don't know that we have time to get into all of them, but what are some highlights there that you really want the nonprofit tenant to understand as they get to the end of this long lease? Their eyes are glazing over.
Yeah, absolutely. So on the landlord's right to enter, the thing to keep in mind, so a lease is always going to say the landlord has the right to enter in certain situations. So if there's a default, often it's even just upon a certain amount of notice. As a tenant, you want to think through, you want to understand it, make sure what's allowed isn't going to interfere with your use. Same with landlords often have right to make alterations or changes. You want to think about that and make sure that what the landlord can do, what the landlord has the right to do, isn't going to impact your use or enjoyment of the space. Usually that's not a big thing, but sometimes landlords want to improve buildings. And it's like, hey, or from the tenant's perspective, like, all right, landlord, you're making this prettier, but you're also closing my main door for 3 months. And that's a huge pain. So kind of think about that. Surrender and holding over. So at the end of the term, the tenant has to get out, tenant has to take all their stuff away, tenant has to repair things they've damaged. That all makes sense. But something that tenants don't often realize is you often need to restore the premises, meaning if you made alterations, you have to undo them. And this is tied to what we were talking about above with alterations. But as the tenant, you don't want to be stuck with surprise restoration or removal obligations at the end of the lease. You'd rather be clear on that at the beginning so you know what work needs to be done. I guess something else, and this can even be tied to the removal obligation, because if you have to remove something and you haven't removed it, the landlord might be able to say you're still in possession and charge you holdover rent. So holdover rent is at the end of the term, the lease is expired. If you're still in there, the lease will say, all right, tenant, you still have to pay me rent, but now instead of just the normal rent, you have to pay me 150% or 200% of the rent at the end of the term. Yeah, that can be a fair amount of money. I mean, separate question whether that's actually enforceable, but that's what the lease says, and that's often the starting point for negotiation. So yeah, at the end of the term, you want to get out. If you think you're going to have issues getting out, preview it with the landlord earlier. Sometimes tenants can negotiate kind of a grace period where holdover rent doesn't kick in for a month or two. That tends to be for bigger tenants. Probably won't get it, but something to think about.
A couple of final topics before we wrap up. Encumbrances, when the many landlords have a mortgage on the building. And so I know there's issues there. And then the rules and regulations for the building. That's another one that I've looked at a lot with tenants. So those are kind of unrelated issues, but a couple of final points that I wanted to make sure we touched on.
Yeah. So encumbrances, this is things like if the landlord has a mortgage. Most landlords will have a mortgage. If the landlord has one at the time you enter into the lease, it's good to try to get what's called a non-disturbance agreement from the lender. And that is essentially something from the lender saying, if the lender forecloses, the lender won't kick out the tenant. The lender won't terminate the tenant's lease so long as the tenant's not in default. Because the way this works, if you get into the nitty gritty, technically, if the mortgage is there first, then if the lender forecloses, then the lender just has the ability to terminate, just completely wipe out the tenancy. That's a really bad situation for a tenant. If you put money into the space, if you've been operating there, if there's a risk that your lease is just terminated, boom, done, that'd be a bad situation. And the other thing is these provisions will often say if the landlord gets a new loan, the tenant agrees to subordinate the lease to that new loan. And if the tenant does that, you're in the same situation where if the lender forecloses, boom, lease could just get wiped out. So you want to ask for what's called a subordination, non-disturbance, and attornment agreement in that situation, an SNDA. And that says the same thing.
That's a lot of...
It's a lot of letters, a lot of words, a lot of legal. But again, the idea is if the lender forecloses, they won't kick you out. And then that's all very technical. Rules and regulations, much less technical. These are often...
But important.
Important, yeah, important. They're usually set up to be readable, which is nice. They're often exhibits attached to the lease. So sometimes people even just straight miss them. So I guess be cognizant, like flip all the way to the back of the lease. But for the rules and regulations, it's good to read through them to see what they say. these address more mundane operational points, but the operational points are actually what people care about. So a common example is no dogs are allowed. That'll be in rule and regulation. Well, a lot of nonprofits, the employees like bringing dogs in. And so you can get ahead of that.
A lot of for-profits.
A lot of people in general, yeah. No, that's true. That's true.
Yeah, it's healthy.
We have some partners that like bring dogs in.
Exactly. And one of the fun ones that I've seen lately is this, the waste management, that the tenants have to sort their cans and bottles and paper and things like that, while, that's not perhaps expensive, it's going to require training a whole lot of people. Maybe in the nonprofits that are earth friendly, it's less of an issue than for your standard corporate office lease. But anyway, yes, those rules and regulations can be very important. I have another tenant that it had to specifically say no incense burning, quiet, pick up your stuff. There can be a lot in those rules and regulations that are relevant. Well, Quinn, I think you and I could probably talk on and on and on and do this for much of the morning. But at this point, I think, if there's any last words of wisdom that you want to give the nonprofit tenant that's looking at a boilerplate lease or these boilerplate provisions, any final parting thoughts on how to get through it and feel confident that the lease that they've come up with is going to serve them well? Yeah,
I think the most important thing is to focus on the term sheet, focus on your business terms, make sure those are all in there and right. After that, if you're negotiating the lease itself, try to limit it to things that are going to directly impact your cost. So kind of operating expenses, responsibility for compliance with laws, responsibility for improvements, and then the assignment and assumption provision. If you focus on those things, 9 times out of 10, you should end up all right without too much headache in getting there.
Yeah, and I think a lot of it depends on the term of the lease also.
Right, that's absolutely.
If it's a really long-term lease and a huge commitment, it's a much more stressful situation understanding these leases. If it's shorter term, smaller space, less mission critical to the organization, then the things you just mentioned, I guess, those are really the highlights.
And yeah, I mean, I've done leases that are over 100 pages. Yet they can be very detailed, very involved. And if it is a lot of space, if it is a big financial outlay, if it is mission critical, focus on it.
But conversely, it shouldn't be too short either.
Right.
The term sheet itself is not enough. As we've shown over this episode and the previous one, there's a lot to think about in leasing space.
That definitely. Although on that, I will say shorter leases tend to benefit the tenants because the more you add, it tends to be more landlord favorable. Like a lot of the default rules in California do often favor tenants. So if you got a 4-pager, maybe just roll with it. I don't know.
Perhaps it's a nice way to wrap up today. If it's short and favorable to you and it's not a huge expense, then you may be fine because default California law. And if you're in California, I'll put it that way. Some other states may not favor the tenants quite so much. Well, thanks again for joining me today, Quinn. It's really been nice having you here. I really appreciate it.
Yeah, it's been great talking.
So as we wrap up today, listeners might want to check out the show notes. We'll have some links to additional resources and other episodes. So that's all for this episode today. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.